Hi everyone. This is All India Bar Exam 17th question paper set C. The first question herewith you can observe Section 12 of Hindu Maintenance and Adoption Act 1956 deals with. So here they have given four options. Rights of adoptive parents to dispose of their properties, effects of adoption, presumption as to the document relating to adoption. Go directly to the Bare Act. So, Hindu Succession Act. You will get the answer. Answer B. Effects of adoption. Section 12 specifies the legal effects when a child is adopted, including that they become the child of the adoptive parents for all purposes, severing ties from their birth family. That is, once the child get adopted, the adopted parents become the natural parents. The adopted child is deemed as a natural child of the adoptive parents for all purposes. And all the remaining ties with the biological family gets cut except for certain marriage prohibitions. Question number 2. Which of the following categories of cases will not be entertained as public interest litigation? Here they have given four options: family pension, petition from the riot victims, neglected children, and landlord tenant matter. So here the answer is landlord tenant matter. Bill does not cover purely private disputes like landlord tenant matter. Who is known as father of public interest litigation in India? So you all know the answer is nothing but the Justice P.N. Bhagavati. Justice P.N. Bhagavati played a important role in the Pill movement in India. Which of the following is not a real purpose of public interest litigation? So here they have given four options: vindication of the rule of law, facilitate effective access to justice, meaningful realization of fundamental rights, getting famous and making wealth. Here the answer is getting famous and making wealth. Pill is not meant for personal fame or wealth, but to uphold the rule of law and justice. In Husseinra cartoon versus State of Bihar, Dash emerged as a basic fundamental right: right to speedy justice, right to clean environment, right to free legal aid, none of this. So here the answer is right to speedy justice. Answer is A. The right to a speedy trial was affirmed as a fundamental right in this case. Which of the following writ can be issued against usurpation of public office? Mandamus, certiorari, quo warranto, prohibition. So, writ of quo warranto is the answer. Quo warranto is used to challenge the legality of persons occupying public office. Ridge v. Balbin's case deals with natural justice. The case established the application of natural justice in administrative decisions. Meaning of audi alteram partem. A person cannot be condemned without being heard. That is, answer is A. Audi alteram partem. Here the term audi here itself showing the meaning of hearing, heard. A person cannot be condemned without being heard. It's a natural justice principle. Everyone must be given a fair hearing. Rules made by Bar Council of India in exercising its rule making power under Bar Council of India Act, that is the Advocates Act 1961. So C is the option. The Bar Council of India draws its rule making authority under the Advocates Act 1961. Which one of the following is not a ground of divorce in the Hindu Marriage Act? Mental disorder, venereal disease, incurable unsound mind, living separately for less than 3 months. Answer D. Living separately for less than 3 months. Explanation. Living separately for less than 1 year is not a ground. So, here the option D is the answer. Indian Christians can obtain divorce under which of the following enactments? Answer is C. Indian Divorce Act 1869. So, Indian Divorce Act 1869 applies to Christians. If any advocate is aggrieved by an order of disciplinary committee of State Bar Council made under Section 35 of the Advocates Act, or Advocate General of the state may prefer and appeal to the Bar Council of India within how many days of the date of communication of order? This is under the Section 35. The answer is 30 days. The limitation period is 30 days. ABC Private Limited Company choose to convert itself into a public company. It can do so by altering its memorandum of association and articles of association and by passing answer is special resolution. Conversion requires a special resolution. Doctrine of lifting off or piercing the corporate veil is associated with company law. Explanation is, so here this doctrine of lifting or piercing the corporate veil is used in company law to look beyond corporate personality. Under which section of the Environment Protection Act 1986 an appeal to National Green Tribunal lies? Section 7A. Which one of the following fundamental duties relates to environmental protection? Answer is B. Option B. Article 51A G. 51A G, according to it, the duty to protect and improve the environment. 51A G. These are fundamental duties. Mr. A, who was aggrieved by an order made by controller or an adjudicating officer, made an appeal to Cyber Appellate Tribunal. Later, Mr. A, aggrieved by an order of Cyber Appellate Tribunal, may prefer an appeal only in High Court. Appeals from Cyber Appellate Tribunal go to the High Court. Mr. X, a person who is intended by Mr. Y, an originator to receive the electronic record, is under the IT Act known as addressee. So, here Mr. X, a person who is intended by Mr. Y, an originator to receive the electronic record under the IT Act is known as addressee. The person whom the record is intended is the addressee. The minimum number of members required for registration of a trade union is 7. So it is according to the Trade Union Act. Coming to 20th question, the text of the certified standing order shall be prominently posted by the employer in which language? So here the question is regarding the standing orders posting and its language, and in the language understood by the majority of his workmen. So language specified in 8th schedule of the constitution is the answer. So must be given in a language understood by majority, that is any in 8th schedule. An advocate may, while practicing, take up teaching of law in any educational institution which is affiliated to a university, so long as the hours during which he is so engaged in the teaching of law do not exceed which hours? How many hours? Here the question per day. So answer is 3 hours. As per the advocate's rules, right to take up law teaching 1979, a practicing advocate can teach law up to 3 hours per day in an affiliated institution. In which of the following landmark case the advocate was held guilty of professional misconduct as he had forged the court order? The answer is Babulal Jain versus Subhash Jain. Explanation: in this case, the advocate was held guilty for forgery of a court order, amounting to professional misconduct. Next, suppose road accident occurs. Then, being an advocate, what is the correct way of approaching the situation? So, here 4 options were given. So, we all know first we have to file the FIR, then it has to go for petition, then summon to the insurance company. That is the order. So, answer is A. The correct approach starts with lodging an FIR, then filing a petition, followed by summoning the insurance company during accident claim proceedings. The principle of ubi jus ibi idem remedium was recognized in. Here 4 options given. Ubi jus ibi remedium means where there is a right, there is a remedy. Recognized in Ashby versus White case. So answer is C. Gloucester Grammar School case is a landmark case based on which of the following maxim? Answer is damnum sine injuria. This case illustrates the principle of damnum sine injuria, damage without legal injury. The National Consumer Disputes Redressal Commission under Consumer Protection Act 2019 shall have the jurisdiction to complaints where the value of the goods or services paid as consideration exceeds rupees. Answer is 50 crores. The NCDRC handles complaints where the value exceeds 50 crores as per Consumer Protection Act 2019. Under Section 41 of Consumer Protection Act 2019, an appeal from the order of District Commission lies to State Commission. Any party aggrieved by the order of the District Commission may appeal to the State Commission. For an individual to be deemed to be resident in India in any previous year, one of the condition is, so here given 182 days, 180 days, 181 days, 360 days. Answer is, if he is in India for a period of 182 days or more during the previous year. Explanation: as per Income Tax Act, an individual must be in India at least 182 days during the previous year to qualify as resident. Mr. Kapoor purchased a residential house in January 2021 for rupees 80 lakhs. He sold the house in April 2022 for rupees 94 lakhs. In this case, the gain of rupees 14 lakhs arising on account of sale of residential house will be charged to tax under which of the following head? We all know it is from the income from capital gains. Profit on sale of a capital asset is taxable under the head income from capital gains. A person who has ultimate control over the affairs of the factory under Factories Act 1948 is called as. Answer is occupier. The person with ultimate control over the factory is termed as occupier under Section 2N of Factories Act. If the factory employs more than 1,000 workers, they should appoint qualified dash to carry out the prescribed duties. Answer is safety officer. Factories Act mandates appointment of safety officers when 1,000 plus workers are employed. B. The proprietor of a newspaper publishes at A's request a libel upon C in the paper, and A agrees to indemnify B against the consequences of the publication and all costs and damages of any action in respect thereof. B is sued by C and has to pay damages and also incurs expenses. Decide in the light of the Section 224 of the Indian Contracts Act 1872. So here, whether A is liable or not liable, we have to find out. A is liable to B upon indemnity. Section 224 says indemnifier is liable to indemnify the indemnified for all damages, costs, and expenses. A person whom the agent names to act for the principal in the business of agency under the express or implied authority to name is called substituted agent. A substituted agent is appointed by an agent for the principal with the principal's authority. A injunction can only be granted by the decree made at the hearing and upon the merits of the suit. The defendant is thereby perpetually enjoined them the assertion of a right or from the commission of an act which would be contrary to the rights of the plaintiff. Perpetual. Answer is perpetual. Perpetual injunction is granted by court order after final hearing and determination on merits. According to Section 5 of the Specific Relief Act 1963, a person entitled to the possession of specific immovable property may recover it in the manner provided in the Code of Civil Procedure 1908. Specific Relief Act refers to recovery to procedure as provided in CPC. Where the mortgager delivers possession of the mortgaged property to the mortgagee and authorizes him to retain such possession until payment of the mortgage money and to receive the rents and profits accruing from the property in lieu of interest or in payment of the mortgage money, the transaction is called a mortgage. It is usufructuary. Usufructuary mortgage involves delivery of possession and authorizes mortgagee to retain possession and take profits. Mr. Manjot is a trader supplying goods from Messrs. Singh Traders. The office of the firm is located in Delhi, whereas its godowns are located in the state of Uttar Pradesh, Punjab, and Jammu Kashmir. Mr. Singh traders made following intrastate supplies from different states during the current financial year. So here his that is supplies, intrastate supplies were given. Delhi taxable supplies, Punjab exempted supplies, Uttar Pradesh taxable and exempted supplies, Jammu Kashmir taxable and exempted supplies. Ascertain the states in which Mr. Manjot is required to take registration under GST. So here Delhi, Uttar Pradesh and Jammu Kashmir is the answer. Registration is required in states where taxable supplies are made. Punjab supplies are exempted, so registration is not mandatory there. The primary GST slabs for any regular taxpayers are presently pegged at. So here four options were given. Answer is 0, 5%, 12%, 18% and 28%. These are the standard GST slabs applied on goods and services in India. So coming to 39th question. Which of the following is not a negotiable instrument under Negotiable Instrument Act 1881? Clearly we can observe promissory note, bill of exchange, check, all these three are negotiable instruments except the billing receipt. Billing receipt is not a negotiable instrument. According to right to fair compensation and transparency in Land Acquisition, Rehabilitation and Resettlement Act 2013, appropriate government can acquire the land for which of the following purposes. So here they have given for strategic purposes relating to naval, military, air force, armed forces of the Union, project for water harvesting, water conservation structure, sanitation, project for project affected families, project for sports, healthcare, tourism, transportation or space program. The answer is all the four. The Act allows for all these four, that is strategic, conservation, project affected families, sports, tourism, healthcare, transportation or space programs. Then coming to 41, specified persons under right to fair compensation and transparency in land acquisition, rehabilitation and resettlement act 2013 means any person other than given here appropriate government, government company, association of persons or trust or society or all of these. So here the answer is all of these. Specified person excludes appropriate government companies and bodies wholly or partly controlled or aided by the government. Who shall be the registrar of trade unions for the purposes of Trademarks Act 1999? So here four options given. Controller General of Patents, Designs, Trademarks, Controller General of Copyright, Designs, Trademarks, Director General of Patents, Designs and Trademarks, Director General of Copyright, Designs and Trademarks. Answer is Controller General of Patents, Designs and Trademarks. The explanation to this is this registrar handles registration of trademarks as per the Trademarks Act. That is the Controller General of Patents, Designs and Trademarks. Which one of the following is not a type of IPR? So answer is historical indications. Designs, patents, copyright, all these three are nothing but the IPR, intellectual property rights. But historical indications, the term itself is wrong because the correct term is geographical indications, which is a type of IPR. In which of the following cases it was decided that a contract with a minor is void? So, Mohari Bibi Here the term BB itself says baby versus Dharmodas Ghosh. Supreme Court held contracts with minors are void. Which of the following is correct with respect to declaratory decrees under the Specific Relief Act 1963? So here option is section 34 of the said act deals with it is discretionary in nature. Section that is here A option, B option. Two options are given. So answer is both options, both A and B. Section 34 of the said act deals with it. It is discretionary in nature. Declaratory degrees are covered under section 34 and their granting is discretionary. That is the real explanation. By which of the following Amendment Act of 1985 anti-defection law was added in the Constitution of India? Answer is B. 52nd Constitutional Amendment Act introduced the anti-defection provisions. Answer is 52nd Constitutional Amendment. Remember properly. In which of the following cases the Supreme Court decided that a constitutional amendment is a law within the meaning of Article 13/2, and therefore if it violates any of the fundamental rights, it may be declared void? Answer is Golaknath versus State of Punjab. This landmark judgment restricted Parliament's power to amend fundamental rights. So, this landmark Golaknath versus State of Punjab. It restricted the Parliament's power to amend the fundamental rights. See the question properly. Okay, in which of the following cases Supreme Court decided that a constitutional amendment is a law? Here the term, remember, law within the meaning of Article 13/2. And therefore, if it violates any of the fundamental rights, it may be declared void. Answer is Golaknath versus State of Punjab. Uniform Civil Code in India is a directive principle of state policy, that is DPSP. Article 44 under directive principles calls for a uniform civil code. As per Article 16, no citizen shall, on grounds only of or any of them, be ineligible for or discriminated against in respect of any employment or office under the state. Answer is religion, race, caste, sex, descent, place of birth, and residence. Here, four options were given. So, A option is correct. So, we have to remember the order also. That is religion, race, caste, sex, descent, place of birth, and resident. So, here the following these grounds are mentioned in Article 16 for equality of opportunity. The minimum number of judges who are to sit for the purpose of deciding any case involving a substantial question of law add to the interpretation of this constitution or for purpose of hearing any reference under Article 143 shall be. Answer is Article 145. 3 mandates at least 3 judges. No, here the answer is wrong. 5 judges. So, Article 143, that is not 145. So, here it's given 145. No, it's wrong. That is 143. So, number of judges is 5 judges, not 3 judges. Remember that properly. Then coming to 51. According to the Article 300A of the Constitution of India, no dash shall be deprived of his property save by authority of law. So here four options given: person, citizen, foreigner, India. Right answer is person. Article 300A protects person against unlawful deprivation of property. So the correct answer is person. Then which of the following is not a law according to Article 13 of the Indian Constitution? So rule, bylaws, custom or usage, none of these. So here custom or usage is not a considered as law under Article 13, whereas rule, bylaws are law according to Article 13 of the Indian Constitution. Custom or usage is not. Which of the following schedule deals with union list, state list, concurrent list in the Constitution of India? So this is Schedule 7. It lists the legislative subjects divided into union, state and concurrent. The title of the Constitution of India is laid down in Article 393. Everybody thinks it is Article 1. No. Here question, understand the question. Title of the Constitution of India is laid down in title of the Constitution of India. Okay, it is in under the Article 393. It gives the title of the Constitution. 393. Remember properly. Article 393. Constitutional provisions of fundamental rights are given under which part of the Constitution of India? So it is part 3, contains the fundamental rights. It's very simple question. Provisions for right of private defense is given between a dash of IPC. So right of private defense is given between sections 96 to 106. IPC section 96 to 106 deal with private defense rights. The consent is not a valid consent under section 90 of IPC. So here if it is given under fear of injury or misconception of fact or given by a person of unsound mind or if given by child below 12 years age. So it's not a valid consent under all of these. If child below 12 years age or is unsound person, unsound mind person or due to fear of injury. All this, if they given consent, it is not a valid consent. Causing of the death of child in the mother's womb is not homicide as provided under explanation 3 to section 300. So it that is it excludes causing death of fetus from homicide liability. So here under section 300 explanation 3 under 2 section 300 death of the fetus, it is there is no liability of homicide due to the death of the fetus. Punishment for defamation under Indian Penal Code is simple imprisonment for a term which may extend to dash or with fine or with both 2 years. IPC provides punishment up to 2 years or fine or both for defamation. Assault or criminal force to women with intent to outrage her modesty under IPC is which kind of offense? So it is actually a cognizable and non-bailable offense. If there is any assault or criminal force to women with intent to outrage her modesty, so it is a serious offense requiring police to act without warrant and non-bailable under section 309 of IPC. A places men with firearms at the outlets of a building and tells Jed that they will fire at Jed if Jed attempts to leave the building. A is guilty of, so four options given: wrongful confinement, restraint, both wrongful confinement or restraint. So answer is wrongful confinement. The person is prevented to move out of the place. So through a threat or force, it leads to wrongful confinement, not wrongful restraint. It is wrongful confinement. The provision of plea bargaining under chapter 21A of CRPC are not applicable if the offense is committed against a child below the age of 14 years. Plea bargaining is barred in offences against children under 14 years. Under Section 82 and 83 of Indian Penal Code, an offence is punishable if it is done by a child of below 7 years, of above 7 years but below 12 years, of above 7 years but below 10 years, of above 7 years but below 12 years without maturity and understanding. So here the answer is B, of the above 7 years but below 12 years having attained sufficient maturity and understanding. Children between 7 and 12 years can be held liable if they understand the act. Okay, so if they understand the act, they are liable. Name two essential conditions of penal liability: guilty body, rightful act; guilty intent, wrongful motive; guilty mind, wrongful act; guilty motive, and wrongful act. Four options were given here. So here we have to always think for a penal liability, the essential condition is guilty mind and wrongful act. That is, guilty mind is mens rea and wrongful act is actus reus. These two are mens rea and actus reus, both are necessary. Which section deal with process to compel appearance under Code of Criminal Procedure 1973? Sections 61 to 90. These sections cover summons, warrants, and other coercive processes. This we have to just directly go to Beract and observe and write the answer. An offense for which a police officer may arrest a person without warrant is known as. So a police officer may arrest a person without warrant. So there are two type of actions of the police: with warrant, without warrant. So cognizable offense. Cognizable offenses allow a police to arrest without warrant and start investigation. In a summons trial case instituted on a complaint wherein the summons has been issued to the accused, the non-appearance or death of the complaint shall entail either discharge or acquittal depending on the facts and the circumstances of the case. So, either discharge or acquittal depending on the facts and circumstances of the case. That is the answer. Court decides dismissal based on the case facts. So, in a summons trial case instituted on a complaint wherein the summons has been issued to the accused, the non-appearance or death of the complaint shall entail. Generally, it leads to acquittal of the accused. But here it's given the answer is either discharge or acquittal, depending on the facts and circumstances of the case. That is the answer. So court had the authority to decide either dismissal or the acquittal. Suppose FIR is not registered by the station house officer. What are the options that the complainant has? So approach superintendent of police, approach magistrate by filing private complaint. None of these, otherwise both. So answer is both. Approach police superintendent, approach magistrate by filing private complaint. Complainant can escalate or file complaint before magistrate. Any police officer making an investigation under Section 160 of CRPC cannot require the attendance of a male at a place other than the place of his residence who is under 15 years and above 65 years. Attendance of males under 15 or over 65 years cannot be compelled outside residence. Section 125 of the Criminal Procedure Code is secular in character was observed in which of the following case? Muhammad Ahmad Khan versus Shabano Begum. Section 125 of the CPC is secular in character. So there is no differentiation with regard to religion, race, okay, so caste. So code is completely secular. So it was observed in Muhammad Ahmad Khan versus Shabano Begum case. This case upheld maintenance rights irrespective of religion. Who had the power of summary trial of a case? Chief Judicial Magistrate, Metropolitan Magistrate, any magistrate of first class specially empowered by the High Court. Answer is all of the above. So answer is Chief Judicial Magistrate, Metropolitan Magistrate, or a specially empowered magistrate hold summary trial powers. Which order of Civil Procedure Code deals with a temporary injunction and interlocutory injection? Order 39 of CPC. It explains about the temporary and interlocutory injunctions. A is a tradesman in Ahmedabad. B carries on business in Delhi. B by his agent Ahmedabad buys goods of A and requests A to deliver to them to the Western Roadway Transport Company. A delivers the good accordingly in Ahmedabad. A may sue B for the price of the goods either in Ahmedabad or in Delhi or only in Ahmedabad or only in Delhi. So answer is either Ahmedabad or Delhi. Suit can be instituted where the seller or buyer resides as per jurisdiction rules. This one you have to remember. Suit can be instituted where the seller or buyer resides as per jurisdiction rules. Which of the following section of Civil Procedure Code deals with the concept of res judicata? Section 11. It bars a suit on the same cause once decided between parties. Mr. X and Mr. Y and Mr. Z are jointly and severally liable for rupees 10,000 under a decree obtained by Mr. A. Mr. Y obtains a decree for rupees 10,000 against Mr. A singly and applies for execution to the court in which the joint decree is being executed. Which of the following option correct for Mr. A? Mr. A may treat his joint decree as cross decree under Order 21 Rule 8. Mr. A cannot treat his joint decree as cross decree under Order 21 Rule 18. Mr. A cannot treat his joint decree as cross decree under Order 22 Rule 18. Answer is that is A. Mr. A may treat joint decree as cross decree under Order 21 Rule 18. That is, Mr. A may treat joint decree as cross decree. Order 21 Rule 18 allows this cross action on a joint decree. A, B, C are co-partners of joint Hindu family. They jointly execute a mortgage in favor of Y. Y files a suit against all of them. Summons is served to C but not to A and B. None of them appears and an ex parte decree is passed against all. A and B applied to set aside the ex parte decree. The decree will be set aside against all the three. That is, only A. Here the answer is given only A and B. A and B can set aside as they were not served summons. But generally, I have seen the answer is all the three A, B, and C. If someone lies before the court on affidavit, how it can be tackled by the advocates? Perjury application can be filed. Perjury application initiates legal action for false affidavit. Proclamation for person absconding shall be published as so publicly in some conspicuous place of village or part of the house or home in which the person resides or some conspicuous place of town or village or a copy is affixed in some conspicuous part of the courthouse. The court may also thinks fit, if it thinks fit, direct a copy of the proclamation to be published in a daily newspaper. So what the options are? Answer is all the four options correct. All given modes of proclamation publication are valid as per law. Which of the following statement is correct? First appeal can be on question of fact or law or both. Second appeal can be on substantial question of law only. Second appeal can be on question of fact or law or both. First appeal may or may not be in the High Court. Second appeal has to be in the High Court. What is that is which option is incorrect that we have to find out. So which option is incorrect? Not here they are asking the incorrect statement. So answer is C. Second appeal can be on question of fact or law or both. That is incorrect. Second appeal is limited to substantial questions of law only. Remember this. Second appeal is limited to substantial questions of law only. Then, as per Order 6, pleading shall mean plaint, written statement, both plaint and written statement or none of these. Answer is both plaint and written statement. Explanation is pleadings include both plaints and written statements. Pleadings include both plaints and written statement. Which of the following order deals with death, marriage, and insolvency of the parties? So already here we learnt that pleading means both plaint and written statement. Pleading includes both plaint and written statement. Remember this properly. So death, marriage, and insolvency of parties is under the Order 22. CPC covers death, marriage, and insolvency. Go directly to Barrett and observe and write the answer. The doctrine of res gestae has been discussed in which section of the Evidence Act? Res gestae, that is section 6. Section 6 deals with res gestae, statements as exception to hearsay. When the liability of a person who is one of the parties to the suit depends upon the liability of a stranger to the suit, then an admission by the stranger in respect of his liability shall be an admission on part of the person who is a party to the suit. It has been so provided under which section of the Indian Evidence Act 1872. Question, please read once again. When the liability of a person who is one of the parties to the suit depend on the liability of a stranger to the suit, then an admission by the stranger in respect of his liability shall be an admission on part of that person who is a party to the suit. It is provided under section 18. It admits admissions by stranger affecting parties' liability. Judicial evidence means, so here four options were given. A is the answer. Evidence received by courts in proof or disproof of facts. Judicial evidence refers to evidence admissible in court trials. So this judicial evidence is either proof or disproof of facts. So it refers to evidence admissible in court trials. Which of the following is not a document according to the Indian Evidence Act 1872? So here four options given: inscription on a metal plate, map, plan, caricature. Caricature is not a document. Inscriptions, maps, plans are considered documents. That is the answer. So answer is caricature is not a document. Presumption as to dowry deaths is given under which section? 113b. Section 113b deals with presumptions in dowry deaths. Section 113b deals with presumptions in dowry deaths. Which of the following is not secondary evidence as per section 63 of the Indian Evidence Act? So here, which of the following is not a secondary evidence? Copies made from the original by mechanical process, copies made from or compared with the original, oral accounts of the contents of a document given by some person who has himself seen it, copies not certified under section 63. D is the correct option. Copies not certified under section 63. Only certified copies or oral accounts are secondary evidence. So whichever not certified under section 3 are not documents. That is, are not secondary evidence. Which of the following provision of Civil Procedure Code 1908 deals with the institution of suits? Section 22 provides for institution of suits. Defendant shall, within dash dash from the date of service of summon on him, present a written statement of his defense. Order 8. That is, answer is B, 30. 30 days is the standard time for filling a written statement. So, defendant shall within 30 days from the date of service of summons on him present a written statement of his defense. The arbitral tribunal shall not be bound by a dash in the determination of rules of procedure. So here, Code of Civil Procedure, Indian Evidence Act, Code of Criminal Procedure have been given. Answer is D, both CPC and Indian Evidence Act. Arbitral proceedings are flexible and not bound by these procedural laws. So our question is, arbitral tribunal shall not be bound by. So arbitral tribunal is not bound by CPC and Indian Evidence Act 1872. Which of the following section deals with arbitration agreement in Arbitration and Conciliation Act 1996? Section 6 deals with definition of the, that is, it defines the arbitration agreement. Under what circumstances the arbitral proceedings can be terminated? Final arbitral award, interim award, where the arbitral tribunal issues an order for the termination. So answer is 1, 2 and 3. Termination can be final award or interim award or tribunal award. So question is, under what circumstances arbitral proceedings can be terminated? So due to final award generally gets terminated. Due to interim award also gets terminated. If the arbitral tribunal issues an order for the termination, then also it gets terminated. Under Section 29 of the Arbitration and Conciliation Act 1996, arbitral proceedings with more than one arbiter, any decision of the arbitral tribunal, majority of its members, decisions are by majority, not unanimity. So, more than one arbiter, if it is having, so majority members has to approve it. Provision for maintenance pendant light in Hindu Marriage Act 1955 is given in section 23, deals with interim maintenance during proceedings. A Muslim wife may sue for divorce under the Dissolution of Muslim Marriage Act 1939, section 2, if the husband has been insane for a period of 7 years. Dissolution of Muslim Marriage Act allows divorce if husband insane for 7 years. Muslim woman has option to be governed by the provisions of sections 125 to 120 of Criminal Procedure Code 1973. Which section of the Muslim Women Act 1986 deals with it? Section 5 preserves maintenance rights under CRPC for Muslim women. Which of the following is not a ground of void marriage under Section 11 of the Hindu Marriage Act? Child marriage is voidable but not void as per Section 11. Sapinda relationship means here four options given. We all know third generation mother and fifth generation father is the answer. So here it's given third and fourth, that is third generation mother and fourth generation father. It is not correct. Third generation mother and fifth generation father, that is correct. Sapinda covers this generation as per Hindu law. A leading question may be asked in during the cross examination. Extrajudicial confession means confessions made either to police or person other than judges and magistrates, confession made by magistrate before magistrates or before judges. Answer is made to police or persons other than judges and magistrates. Confessions outside the court or magistrate's presence are extrajudicial. Thank you.